We are finally getting a picture of how the racketeering and conspiracy case against Donald Trump and 18 other co-defendants, we're finally getting a picture as to how that might play out in court in Fulton County, Georgia. And boy, oh boy, is it a complicated picture. As you may know, two of Trump's co-defendants in all of this, Sidney Powell and Kenneth Chesebro, lawyers, they each asked for their trials to go forward next month on October 23rd, ahead of everybody else's trials. And today, Judge Scott McAfee officially separated Ms. Powell and Mr. Chesebro's trials from the rest of the people charged in this case. Judge McAfee wrote in his order that separating these trials is a procedural and logistical inevitability, and that additional divisions of these 17 defendants may well be required. So we may get to see this case broken up into even more smaller groups of cases, which sounds easy and it sounds reasonable, and it also happens to be unbelievably convoluted. It is literally the most head-spinning version of trial Tetris you have ever seen. Here are the 19 defendants in this case. As I mentioned before, Kenneth Chesebro and Sidney Powell will now officially be tried together and separately from everyone else. But as for the other 17, Donald Trump, John Eastman, Jeffrey Clark, fake electors Sean Still, David Schaefer, and voter fraud conspiracist Robert Cheeley, they want their cases split off from anybody who wants a speedy trial, which so far is just Kenneth Chesebro and Sidney Powell. Rudy Giuliani, meanwhile, doesn't want to be tried alongside Chesebro and Powell, and it looks like he's going to get his wish. Former Chief of Staff Mark Meadows wants to be tried all by himself in federal court. But unless his appeal goes his way, that is not going to happen, and right now it doesn't look like it will. Mr. Scott Hall wants to be tried separately from all the defendants who were not accused of crimes related to the alleged voting machine breach in Coffee County. Harrison Floyd wants to be tried only with the other people accused of harassing elections worker Ruby Freeman. Two of the remaining three co-defendants have not yet filed any motions to sever their cases. But Ray Smith, a former lawyer for the Trump campaign, has told the court he thinks the co-defendants should all be tried in, quote, manageable groups, whatever that means. It is like the seating arrangement from hell. Only the stakes are, of course, astronomically higher. For now, what we can say for sure is that Kenneth Chesebro and Sidney Powell look like they will be the first co-conspirators in this case to face justice in a courtroom. The judge said today that he expects the jury in this case to be selected by November 3rd, which means lawyers could start presenting arguments to that jury well before the end of 2023. And we are getting a look at what that might be like as well. Today, lawyers for Ms. Powell and Mr. Chesebro are in court arguing about what kind of evidence they will be allowed to use in this case. And there was a lot of disagreement. So much so that at one point, the judge had to admonish Chesebro's attorney after he accused the prosecution of defaming the defense.
So the fact that she got up here and lied to the court.
All right, Mr. Grumman, I don't think we need to go down that road.
Your Honor, she lied to the court, and I apologize, and she defamed my co-counsel.
I've said it's over.
All right. Well, I wish you would have stopped her from defaming my co-counsel.
Okay, now multiply all of that kind of tense exchange, multiply it times 17 defendants all at once in the same courtroom. And you have a window into how untenable a trial for the 17 remaining defendants happens to be. It is not tenable. But we are not sure exactly what happens next. What we do know is that two of the 19 co-defendants are going to trial on October 23rd. According to the prosecution, it is going to take 4 months to try that case. Trump himself still does not have a court date, but the judge has set a hard and fast deadline of December 1st for the 17 other defendants, including Donald Trump, to submit any pre-trial motions. Judge McAfee has made very clear that he is not going to slow walk this case. He does not appear ready to let Donald Trump push this case into the distant future, which means that 2024 is going to be a very, very busy year. Buckle up. Joining me now is Neil Katyal, former acting solicitor general for the Obama administration, and Christy Greenberg, a former federal prosecutor and former deputy chief of the criminal division in the Southern District of New York. Neil and Christy, thank you for being here tonight. Christy, seems inevitable that the 17 others are going to be divided up. But as we've just pointed out through the extensive and, may I say, sophisticated graphics department here at this program, dividing up those 17 is Tetris from hell. How do you think the judge is going to begin to go about it, and what are the priorities in terms of determining these next groups?
So when I've prosecuted large cases having 20 to 30 people in the case, usually the judge will ask for some input about the groupings of defendants, say, if the evidence is all related to the Coffee County scheme, for example, would it make sense to try all of those defendants together so that you're getting an overlap in the counts and the evidence that the jurors are going to be hearing. Same for the other schemes. You've got very discrete schemes, even though it's all one big RICO conspiracy. So the prosecutors are probably going to provide that input about what makes sense. The judge also signaled he wants to hear what the pretrial motions are. What kinds of defenses are these different defendants going to raise? And maybe, depending on those defenses, that could affect the groupings as well.